Court of Appeal in the 4th, 5th District in the state of Florida is now in session. The Honorable Harvey J. Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, this honorable court, and the state of Florida.
Please be seated. Good morning. This is actually the second oral argument we've had today. Of course, you were not part of the first one because the first one was by Zoom. But welcome to the 5th DCA, the reconfigured 5th DCA. As I believe I know both of you on both sides, my name is Harvey J. I'm presiding today. I had the privilege of presiding Tuesday for the first time on the reconfigured 5th DCA. Again, I have the privilege of being here with two very fine judges, Judge Soud and Judge Boatwright, who you probably both know as being fine judges on the trial bench, and I am certain they will be very fine colleagues here on the reconfigured 5th DCA. If there is nothing further for the court, I do need to tell you one other thing. We are planning to take a very short break in between these two oral arguments this morning. So after this oral argument, we'll take about 5 minutes before we come back for the second live OA of the morning. But Ms. Cohen, are you prepared to go forward? All right. And how much time would you like for a rebuttal?
5 minutes.
We have that in place. Well, thank you, Ms. Cohen, when you're ready.
May it please the court. This trial began with a jury selection wherein the state asked the potential jurors about their trip in that morning. And she asked what they thought of the traffic, and they responded that it was horrible. And if that had been leading to something else, that would have not in and of itself been so much of an issue. But we proceeded from there to, did someone cut you off? How was your experience? Have you ever encountered an aggressive driver? How did that make you feel? What are some reasons that you have to pay attention while you're driving? And the first response to that was so you do not cause an accident.
So your argument, Ms. Cohen, is trial counsel for your client was ineffective for not objecting to those questions?
Yes, sir. And the problem is because each one compounded on the other. So we start with the aggressive driver, and how did that make you feel? There were no follow-up questions from either attorney as to how that would impact their ability to judge a DUI case and what impact that would have and whether they could make a fair and impartial decision.
Well, and I have two questions about that. And I know you know this, Ms. Cohen. The edicts from the U.S. Supreme Court tell us that we are to be deferential to trial strategy, and you appreciate that, correct?
Yes, sir.
Is it not sound trial strategy to avoid objecting in front of potential jurors?
If it's over the top, I guess, and if it's a minor thing, then yes, there might be some strategy to do that. But there comes a point where there is absolutely no strategy, and allowing a prosecutor to continue to go along the vein of the dangerousness of what occurred in this case, as opposed to the actual issues on a DUI. Were you driving? Were you impaired by, in this case, alcohol, to the extent your normal faculties were impaired? The jury was not being called upon to decide whether or not there was dangerous driving in this case. The jury was not being called upon to decide whether DUI should be illegal. The jury was not being called upon to decide whether it's safe to drink and drive. The jury wasn't being called upon to decide any of those things. So the questions posed to the jury got all the way to, wouldn't you agree that this is a danger? If we allow this behavior to continue, that this is a danger to people and pedestrians. And by the way, Miss Third Grade teacher, don't you have children in a crosswalk? And so it just progressed from one point on. So maybe you don't object the first time, the second time. The third time you object and you ask to approach.
What would have been
bench.
the objection? What should he objected to? What was
The
the legal
objection would
objection?
be that the questions were not to get to the issue of whether or not these jurors were fair and impartial, but to inflame the jury, to test your case in front of the jury, to give them hypotheticals about, because obviously, as we found out later on, that was the issue in this case, was a witness who asserted this was an aggressive driver. And so what it did was it took the focus off of what the actual elements of the offense were. And the bigger issue is...
So you're saying the state's not allowed to ask hypothetical questions during jury selection?
Not regarding the specific facts of their case. They can, and obviously any kind of question that is geared towards determining somebody's, whether they're impartial or not. But these questions nobody ever asked these people what that meant to them, how it affected their ability to be a juror.
But you said the facts of this case, as I read the transcript, there was no reference to this case during voir dire. It was just general questions, correct?
General about aggressive driving. Again, that's not an element of DUI. And if there had been, have you been exposed to aggressive driving, things like that, or does that concern you? How would that affect your ability? And the defense attorney didn't come back and ask that question either. So there was no follow-up that might have made it different if there had been some follow-up. But the problem is there was no follow-up as to how that informed whether or not this juror was going to be fair and impartial. It only laid the groundwork for, oh my gosh, this is dangerous, what happened here was dangerous, this is why we have to have these laws, because people can get killed, children can be hit in crosswalks, and that was what the focus was of the state from the very beginning. The state even talked about field sobriety exercises and tells the jury that this is a good way to determine normal faculties. A police officer shouldn't just let someone go, should they? So...
How do we know it made a difference?
Because even if this court were to find that this wasn't enough to compromise the jury, which I would suggest that it would be, because by the time she finished, the whole focus was, this is dangerous and you got to do something about it. But once you put that together, and I understand if this was correct questioning of the juror, then obviously it doesn't add to a cumulative error. But because it was not, even if this court were to say, well, that in and of itself is not enough. What happened after this? In opening, the very first statement was
Is that something we could find, this in and of itself was not enough?
My position and my belief under the law is no, you can't. But obviously the court could differ with that belief. And so if the court were to disagree with me about that, wouldn't be the first time, then even if you took that apart, the very first thing in opening statement is the statement that there's a truck in front of us and he's going to kill somebody. Again, not an element of the offense, but again, carrying through. On the 2 pages of transcript where the questioning...
Wasn't that her testimony, though?
It was the testimony, but it, number one, puts the focus on... Well, let me back up. Obviously, if there had been some sort of pretrial motions, which the attorney didn't believe he needed to do, about some of that language, because while some of it is certainly relevant and the actual driving pattern may be relevant, then but you also need to get into whether the prejudice may outweigh the relevancy of the woman's conclusion. But by focusing...
So you agree that would have been maybe, you're talking prejudice, but it's relevant, her testimony as to why the officer started the investigation in the first place,
Why the officer
correct?
started it, yes, sir. But into that particular phase, but again, it dovetails into the focus from the very beginning of this is dangerous. Then 9 times, I take that back, 9 times over 2 pages of testimony, which also gets into the opinion of the prosecutor, which she gave them during jury selection about field sobriety exercises, and we all agree that DUI is dangerous, or that being impaired is dangerous. She then goes into when she's questioning the witness. When did you first see this reckless driver? What did you do about this reckless driver? 9 times uses the phrase reckless driver. So now we have jury selection where the whole focus is on reckless driving, danger to the community, hitting children in school crosswalks. Then we get to the very first statement to the jury in opening about somebody's going to die. Then we get to this being a reckless driver in the opinion of the state, 9 times over 2 pages of transcript. Then
What about the testimony of the lawyers? I remembered, I believe, dealing with this, that if you object to something like that, you give it undue emphasis with the jury. Is that not a reasonable evaluation point, that objecting to things sometimes bring those things to the attention of the jury?
Certainly, if it was said one time, yes. But by the time you've said it 9 times in the period of, I don't know, 5 minutes, or maybe 10 at the most, then I think that has already focused the jury on that term that you are referring to, especially once you have already told them that this person almost killed somebody, and you've told them in jury selection about the dangers and that killing children in the crosswalks. Then you get to the video, where we have a redacted video, and there's no objection to the video. So we're watching the video, and in the video, the officer's telling him about another witness and what that other witness had to say, who's not testifying, and it's clearly hearsay. And that's in the redacted video. And then at the end of the redacted video is the statement of the officer, first of all, first making contact with the witness, saying, I need to talk to you, and then saying, carrying along the same theme, I just investigated a crash here 3 weeks ago with the same, and the same circumstances. Again, that is not relevant to this case. That is not relevant to guilt or innocence. That just carries on the same focus from the very beginning. And I'm not standing here saying that anybody thinks that driving under the influence is a good thing, and our personal opinions as to whether there should be a law or shouldn't be a law and whether it's dangerous is certainly something we're entitled to and something that's important, and I think we all agree. But that wasn't the question in this trial. It was, was this person impaired by alcohol?
Let me ask you this, Ms. Cohen. Was there evidence in this record? I appreciate the argument. You've done a nice job laying it out in your briefs and today. But was there evidence in this record where a jury could find what they found as to your client?
Well, it depends, because if the question before the court is, if, first of all, there had been a motion to suppress based on the reasonable suspicion and everything got suppressed about the original, everything past the original stop, then obviously, no, they could not. But even if you take out the pretrial motions, if you take away all these statements during jury selection, if you take away the statement during opening statement, if you take away the repeated references to reckless driving, if you take away the fact that that defense attorney is the one that elicited some of the most damaging evidence from the arrest officer, he knew what that officer would say, and he gets up and the first question is, oh, you know, all you've said is odor of alcohol. Tell us more. What are some of the other indicators of impairment that you saw? So if you take that out, the other indicators of impairment, which were then argued by the state, if you take out the additional evidence of rudeness and intimidation by the breath test operator that the attorney elicited, if you take away the repeated, I think it was 10 times during closing that the prosecutor said he is guilty. He was so impaired that night. He was impaired by alcohol. He was guilty of DUI. The very last thing the prosecutor said was that the witness said she thought somebody was going to die. So if you take that away, you take away all the opinion, you take away the jury instruction errors, you take away the hearsay in the video, you take away the evidence that was elicited by the attorney. If you go back and you look at whether or not they had brought in medical evidence about his medical conditions that went into the decision to refuse field sobriety exercises, which became an issue. And I understand a defendant can testify to that, but I would suggest that it is not sound strategy to say that a jury is going to look at a defendant who says, yes, I have these medical conditions, in the same way in which they're going to look at an expert. And the explanation for the attorney was, well, he never gave me his medical records. There was no evidence that he asked for them. And that's the problem with the strategic aspect of this. There was no testimony that he actually investigated anything, and even when he talked about the strategy, he was not prepared. He's like, I don't really remember. I didn't look at my file. I didn't bring my file. I think that's as telling as anything else. And so even when he tried to use the buzzword strategy, it was a situation of, I don't remember, but I wouldn't have done this. I don't remember the state asking the jury anything inappropriate. I don't remember any inappropriate answers. That's not talking about a strategy. in the, and I know the court's familiar with McKendrick out of the 1st District Court of Appeal, one of the things the attorney there, when the court
So back
overturned,
to my
was
question,
they
Ms.
explained
Cohen,
everything.
and I know you've given a long answer, but you're saying there was insufficient evidence here for the jury to find what they found?
I think that it undermines the confidence in the verdict, and I think that it could,
And I appreciate
there's a
that.
likelihood that it did affect it, because if you take out all of that, what's left? And so even the officer, before the defense attorney asked him, the arresting officer said it was the driving pattern and I smelled alcohol. That was it. That was what he said.
Driving pattern, smelling alcohol, your client's admission that he had had multiple beers, I think 2.5 is what he conceded, being in the wrong place
That
is...
came,
Well, didn't that come out at the McDonald's? or
it did,
not?
but he also explained being lost. And again, the officer didn't say that counted as part of his belief that he was impaired until after the defense attorney asked him. So that's the problem, is a lot of that stuff that the court is referring to and that the jury was told in closing argument was evidence that was elicited by a defense attorney who had prior knowledge, who admitted he never spoke with the first woman, who, and I don't know if you noticed this, she said she followed him for 30 minutes, and they talked about that, but the 911 call is about 7 minutes, and she said she watched him for 2 before that. We didn't hear about that either. So the problem is there was essentially no defense put forth in this case. If you read the transcript, there is no affirmative defense, none at all. There is no testing of the state's case in this transcript. That it is basically the state was able to turn it into a referendum on how unsafe it is to children in the crosswalk for people to drink and drive or have any alcohol, that the prosecutor who told the jury in jury selection it's important to have somebody with training and experience to help us know what's impairment, and then tells them no less than 10 times in closing, he was impaired, he was DUI, he was impaired, he was so impaired, he is guilty. Not, I think that's what the evidence will show, I think that's what we'll see, and I see I'm in my rebuttal time.
All right, thank you, Ms. Cohen. You'll reserve the rest of that time for rebuttal. Mr. Lawden, are you prepared to proceed?
Yes, Judge.
When you're ready.
Your Honors, Counsel, may I please the Court? Zach Lawton for the State of Florida. Williamson begins his reply brief, regardless of the arguments and factual recitations put forth in the briefs in this case, the actual record is the best argument for reversal. And that's exactly the problem with his motion. He points out things that counsel could have done differently, makes a boilerplate argument for prejudice, and then kind of expects the courts to dig through the record and figure it out regardless of the arguments and factual recitations in the motion and the briefs. The question, of course, before this court is whether the trial court erred when it denied Williamson's motion, not whether there may be evidence somewhere in the record that may show ineffective assistance of counsel. But let's talk about that record. Now, it's easy to play Monday morning quarterback, but when you read the record, what you don't see is any evidence that counsel was not functioning within the wide range of reasonable professional assistance, which is what Strickland requires. The record does not show a defense attorney who is incompetent or just phoning it in. It may show that in hindsight, certain questions could have been asked differently, or evidence could have been presented differently. But Strickland requires reasonable professional assistance, not perfection. It also requires a probability that deficient conduct affected the outcome of the proceedings. Now, that's the big picture, and I want to talk about 4 big picture things before getting to the specifics. First, a big picture, it's important to look at the pleadings. The pleadings were very factually based. This happened, without much argument as to why anything was deficient. And I think that's important because that's what was before the trial court. The second big picture thing is prejudice. I want to read, in the original motion, this was the entire argument on prejudice, and it's page 10 of the motion. I'm not sure what page of the record. It says, the transcript of the trial shows that breath test results The breath test result was the focus of the trial. Now, the state would disagree with that because there was no breath test result, and the focus of the trial seemed to be Williamson's driving. But then after that, the above actions and inaction by defendant's trial counsel was so deficient that he was not functioning as the counsel guaranteed by the Sixth Amendment, and the deficiency served to deprive the defendant of his right of a fair trial. The defendant has suffered prejudice, as there is a reasonable possibility that but for counsel's error, the result of the proceeding would have been different. This probability is sufficient to undermine confidence in the outcome. That's completely boilerplate. There's no explanation at all of how any of this deficient performance prejudiced Williamson's case. The third big picture is look at the evidentiary hearing. Williamson often just failed to meet his burden at the evidentiary hearing. We have a lot of arguments that require evidence. The deputy was not called at the evidentiary hearing to testify. Williamson did not testify at the evidentiary hearing whether he felt that he could leave when the deputy parked behind him. There's no evidence in the evidentiary hearing about Williamson's medical issues. There's no expert testimony that someone with his medical issues could not have done a field sobriety exercise.
Why did it matter that the detective was not called at the evidentiary hearing? Why, from the state's perspective, did that matter, and why was that dispositive?
Well, we have arguments in the brief about what the deputy knew. And there's an assumption that because maybe one 911 call or one dispatch call didn't have certain information, that the deputy also didn't have that information. But if the deputy were called, the deputy could explain whether maybe there was another call. The deputy could say what information he actually had at the time.
Was that dispositive, the deputy not being called?
Well, if everything were taken to be true that Williamson has argued, then I think it's still important what information the deputy had, because if the deputy, so they say, well, the deputy didn't have the license number because that wasn't in the dispatch call. Well, if there was another call that gave the deputy the license number, or if there was another way that the deputy knew the information that was in the original 911 call, then that certainly would be important in a motion to suppress. And that evidence would not have come out at trial because it all would have been hearsay. And the fourth big picture item is Williamson talks a lot about the recklessness becoming such a feature, such a theme of the trial. But Williamson has not answered the Brown case, and Brown was referenced in the answer brief. It's a 5th DCA case that says that reckless driving is an indicator of impairment. And so saying that his driving was reckless and dangerous was certainly relevant to determine whether he was impaired. Now, on the specifics, I'd like to focus on the grounds that were argued in here and rely on my rely on my brief for the other grounds, unless your honors have any questions about them. So first, looking at the B ground. The lack of objection during voir dire. Now, what we heard was that there's never any follow-up question to explain what some of these questions were about. When counsel asked about the dangerousness or whether you've encountered aggressive drivers, things like that.
Mr. Lawton,
Yes.
you stated in your brief that defense counsel conducted a thorough voir dire. What exactly do you base that on? Can you give some examples?
Well, he certainly if Your Honor could give me a minute. Well, he asked the jurors about some different topics. Now, they suggest that he should have asked about more different topics or other topics, but they never explained what topics should have been addressed. Let's see. And off the top of my head, I'm not remembering anything else specific from the voir dire. The crosswalk issue was certainly harped on. I think that this is another example where there's just no way to show prejudice, because what happens if counsel were to object to the crosswalk question? Then we have the question out there, is an impaired driver a danger to kids in crosswalks? And then there's an objection. So the jurors have heard the question. You can't unring the bell. But what do we get when there's not an objection? We get the response from the juror, which is, oh, our kids aren't in crosswalks. So there's no evidence there that the juror was inflamed in any way. The juror simply said, oh, that's not really an issue. We're not worried about that, which was much better for the defense than had there been an objection and the court made the state withdraw the question. And it was important to find out the jurors' feelings on...
And to understand what you're saying there, a lot of times it's more deleterious, detrimental when a question is not answered, because then the potential jurors may think about what the answer would be. And you're saying here the answer was given, it eliminated the problem, and so it turned out to be sound strategy by the defense attorney.
Yes, Judge, I would agree with that.
All right.
And it was also important to find out the juror's potential bias about driving under the influence. That bias can go two different ways. You could get an answer from a juror that, well, DUI doesn't seem like such a big deal to me. You have a few drinks, you drive. As long as you don't actually kill somebody, it's not a big deal. The state doesn't want that juror on the panel. But at the same time, you could also have a juror say, well, my brother was killed by a drunk driver, and that could lead to questions about, well, do you think you couldn't be fair and unbiased? And the juror may say, yes, I don't think I could be fair because this is too important to me.
Isn't there an argument, Mr. Lawden, that oftentimes in jury selection it's better to have more information than less for the reason you just said, so you can evaluate whether potential jurors can be fair and impartial?
Yes, Judge. And in the crosswalk question, that would have been very important to find out whether that teacher had a specific bias about DUI because of worrying about the children in crosswalks. And
so that's why a lot of good trial lawyers ask open-ended questions in voir dire.
yes, Judge. And open-ended questions can, in both voir dire and in trial, they can find out information that can be helpful that may be unexpected.
And I guess my focus is on voir dire because, again, if you're defending a case, if you're on behalf of the state prosecuting the case, it helps to have more information in order to evaluate the objectivity of that potential juror.
Yes, Judge. And that information can come from questions asked by the state or questions asked by the court or questions asked by the defense. And I think, speaking of kind of open-ended questions, one of the arguments that is made by Williamson is that there's absolutely no possible reason to in the cross-examination of the officer, to question him and say, well, what were the other indicators of impairment? And I think that's another case where the jury's imagination could be an issue. The testimony in direct by the officer was that one of the indicators I saw was that I smelled alcohol in his breath. That implies there are other indicators, and the jury hears that, the jury's imagination starts going, and they think about what the other indicators could be. And so it's important for that reason to establish what those indicators are, because you don't want the jury thinking about what else the officer might have seen that might have been a reason to convict. The other thing is that defense can't answer those indicators without knowing what they are. And so if you've got this kind of nebulous answer that there are other indicators and the jurors are wondering what they are, you can't get up in closing argument and argue that those other indicators are not evidence of impairment if you don't know what they are. So it was important to the defense to get that information, even though it may have at some point been hurtful to get some of that information. For example, the argument being made that it wasn't much of an indicator that he saw Williamson walking into the McDonald's. Well, that's not an argument that would have been made and couldn't have shown that, well, this is a bad indicator if that evidence hadn't come out. And okay, well, so in general, what we have is a complete inability to state what prejudice was. We have a very boilerplate explanation of prejudice in the motion, and what we have in the end in this case is we have Williamson's admissions that he was driving and that he had been drinking. We have the 911 caller's observations of his very reckless driving, and that is an indicator of impairment. And we have his confusion. He's going the wrong way. He's going away from the airport and says he's going to the airport. Also his confusion, he thinks that McDonald's is open when it's not. And of course, the officer smelled alcohol in his breath. Those are, that all very strong evidence of DUI and certainly gave probable cause for an arrest. If there are no other questions, I'd rely on the briefs.
Thank you, Mr. Lawton. Ms. Cohen, rebuttal?
Yes, sir. First of all, I don't believe, and I would disagree, that it's good strategy to bring out as much negative evidence as you can about your client so then you can try to refute that evidence in closing. In closing, the proper thing would be the only thing you heard today was the odor of alcohol. That, as the judge will instruct, you have to base your decision on the evidence before you.
But what about the notion, and I just heard it from Mr. Lawton, that during voir dire you want transparency, you want potential jurors to speak, correct, Ms. Cohen?
Correct, but the problem is not what the question, not even just the questions, it's everything the state told them. And then there was, again,
let me stop you there. In my experience, having tried cases as a trial judge and a trial lawyer, and now as an appellate judge, a lot of times when the jury doesn't hear the answer to the question, it causes more questions. So wasn't it potentially efficacious here that they were allowed to answer those kind of questions?
The problem is when it started going down that road, the proper thing to do, I would suggest, is to approach the court and say, we're going down a road that is not proper here. So before the rest of the questions get asked, so you don't even get to the point of children in the crosswalk, that originally and initially an objection and asked to approach the court. Same thing with the 9 comments about reckless driving. If you object the first time and you address it, or even the second time, and you address it, you don't have to do it presumably 12 times or 10 times or 9 times or however many times. The problem is if you're not objecting from the beginning, then it just continues and it continues. If you look at everything, in terms of first of all, in terms of responding to some of the procedural issues, obviously those were not raised below. There was never question about the sufficiency of the motion. There was a hearing. I realize there was a typo in the original motion. There's a typo in one of the briefs that the state wrote about the standard of review on a summary denial, which this wasn't. This isn't about any of that. This is about the evidence. The motion outlined factually what the issue was, didn't repeat in every single paragraph this prejudice, because the issue here is not isolated comments, and it's not minor or brief situations. It is that the overall picture of what was put in front of the jury so compromised the jury's ability to fairly evaluate the evidence in front of it. No one ever asked the jurors how any of what they heard affected their ability to be fair and impartial. No one ever said, do you think that your concerns about DUI would cause you to be fair and impartial? They talked to the people who had family members or who said, I think police would be more honest. But in terms of field sobriety exercises and the state telling them they're a really good test of if somebody's impaired or not, all of that, there was no follow-up. There was no questioning about whether or not that impacted their ability to sit and be fair and impartial. So nobody learned anything from that because there was no response from the jurors as to how any of that would impact their ability to sit in their case. This is not a case where it's a nuanced claim of ineffective assistance. This is almost an in-your-face claim in terms of how it started, with everything that was stated to the jury in jury selection, to the very ending where the very last thing stated to them was he could have killed somebody, which is not an element of the DUI. In terms of the error, again, I think that we've laid out all the errors. I know I haven't mentioned all of them today, but they're in the briefs, that Mr. Williamson did meet his burden, that the trial counsel really had no explanation for anything he did other than, I think, maybe, or the thing that the court has raised about, isn't it sometimes wise not to object? And yes, it is. But by that token, if you carry that theory over, then it would never be appropriate to object, because you either want to bring out bad information so you can make sure you can rebut it, or you don't want to stop the trial, or you don't want to look bad in front of the jury. But clearly, sometimes you just have no choice. And this was a clear case, number one, of where you had no choice. And then to say that it's good to learn new information in a trial, I think that in and of itself, if that is the strategy, if you're in a trial as a defense attorney, trying to learn new information at that point, that in and of itself is a problem. And I'm done.
All right, thank you. I'm not sure why we're beeping, but that may be operator error on my part, Ms. Cohen. But I'll give you 10. I'll give you 10 seconds to close.
I'm done.
Thank you. Thank you both. We are going to take a brief recess ahead of our next argument. Why don't we plan to be back? I think we were set anyway at 11:30. So why don't we plan to be back at 11:30 for the next oral argument? But thank you both. It was professionally carried out, as I knew it would be. Good to see you both. It's been a while, and we'll be in recess until 11:30.